K. George, and all senior members and friends. Today we have a CPE seminar on virtual mode on analysis of Companies Amendment Act 2020. May I request our chairman, Sir Roy Varghese, to welcome our speaker and other participants.
Very respected Dr. P.V.S. Jagan Mohan, sir. Immediate past SAFA chairman and regional council member, say Mohan K. George, sir. Senior members, colleagues and friends in profession, and my colleagues in Managing Committee of Ernakulam branch of ICAI. Good afternoon to all of you. Welcome to the virtual webinar on analysis of Companies Amendment Act 2020, organized by Ernakulam branch of ICAI. The Companies Amendment Bill was recently passed by Lok Sabha and Rajya Sabha and subsequently got the assent of the President of India. Of the Companies Act 2013 and lightening of rigor penalties provided in the Companies Act 2013. There are amendments of around 61 sections in the Act and addition of 4 more new sections. To address us and lead the discussion today, we have with us Dr. P.V.S. Jagan Mohan Rao, who is a well-known practicing company secretary and cost accountant. More than that, he was the immediate past president of SAFA and past president of ICSI. During 1920, Jagan sir visited us, our branch, when Srinivasan was the chairman. He's a very good friend of Ernakulam branch, and we are very happy to have Jagan sir with us today. On behalf of Ernakulam branch of ICAI, I extend a cordial welcome to the resource person today, Dr. P.V.S. Jagan sir, to this webinar. Welcome, sir. We have with us today C.A. Mohan K. George, sir, the immediate past chairman and member of SARC. He specifically, even though he is very busy today, he specifically accepted our invitation and is present here today. It's my pleasure to remind you all of you that Jagan sir is our future hope to represent all of us in the Council of ICA after Babu sir vacates his office. So it's always a pleasure to be with Jagan sir, who always supports the branch. On behalf of all of you present here today, I welcome C.A. Mohan K. George sir to this webinar. Let me welcome all my fellow colleagues in Managing Committee, particularly the Secretary C.A. K.V. George and all others present here today to this webinar. Finally, it is my pleasure to welcome each and every one of our seniors, colleagues and friends in profession attending this virtual meeting today. Friends, I hope today's session will be very useful to all of you because the amendments in the Companies Act is very relevant and very useful in our professional service. And be here with us today throughout the session and see that we would like to see your active participation in the deliberations also. That's all I want to tell you. Thank you very much for the patient listening. Over to Joss for the proceedings, please.
Thank you, Chairman Sir Roy Varghese. Now may I request our regional council member, Sir Joman sir, for his address and opening remarks on this analysis of the Companies Amendment Act 2020. Over to Joman sir. It's mute. It's mute.
I'm audible now?
Yes, yes.
Yeah, good afternoon to all of you. Very dynamic chairman of our branch, Sir Roy Varghese, has spoken so much good about me. Thank you for that. Secretary K.V. Jose, who is coordinating this program, and a very learned speaker for this afternoon, Dr. P.V.S. Jagan Mohan Rao, a professional extraordinaire, a man with global exposure in IFAC, in SAFA, and has been the president of ICSI and also council member of the Institute of Cost Management Accountants of India, with whom I had the pleasant privilege of interacting on a few occasions. Last year, many of the programs of SARC and the branches he has there as a very, very strong resource person, and it is his passion to have this knowledge dissemination. We are extremely fortunate to have him in our midst. But sir, this being the tax season, tax audit, then you have the GST annual returns, and mix of all these, maybe the attendance may not be as much as you think, but as we know you, you are the person who sets a trend, sets the ball in motion, and saying that, okay, here is Companies Amendment Act 2020, which should be referred to, and it should be applied as well as becomes an integral part of the law as we move forward. As the chairman rightly said, 61 sections have been amended. 4 new sections have been introduced, including producer companies. The spirit of these amendments, as you've seen, in the past 2-3 years, we have been talking about ease of doing business. And also many of the provisions of the Companies Act 2013, as it rolled out in a hurry, even 7 years down the lane, they're very highly punitive. The penalties are very high. Plus, there is imprisonment provision in almost all even for not a very serious offense, for a light offense also, it goes to the extent of imprisonment and related high penalties. So it's very important that as India is now galloping forward as a very fast-growing economy, and the whole world are looking at China with so much of disfavor, expecting a lot of corporates from across the globe coming to India and setting up shops here, it's very important that the law that regulates corporates, that is Companies Act 2013, has to be friendly in one sense. It should not be scary, at least. If it is not friendly, it should not be scary as the provisions of imprisonment and so on. And therefore, there's decriminalization. So it's a very welcome move on making the Companies Act a little more investor friendly, and that is the way we slowly scale up on the ease of doing business index. We came out with a GST subsuming 10 indirect taxes. We came out with the IBC, Insolvency and Bankruptcy Code. It's all making India more transparent in its dealings. And for a foreign investor who sets up to invest huge amount of money in our country, he should feel comfortable, safe, and he should feel that kind of immunity is provided. So this is the spirit of the Companies Amendment Act 2020. Extremely happy that Jagan Mohan Rao sir is back in Cochin, I can say. Though virtually, sir, we would have really loved to have you physically in Cochin. But I salute your spirit, undying spirit. Relentlessly, you're working in knowledge dissemination, as I mentioned earlier, reaching out to as many people as possible of the 3 professions, which are the very important professions today with corporate governance requirements, financial discipline, and all that. Chartered accountants, cost and management accountants, and company secretaries. We have to work together in making implementing the law happen and bringing about governance. That is the way forward, particularly for an India which is now growing substantially faster, barring the temporary setbacks. As we know, the GDP is expected to shrink by about 10% this year. The actual figures may even go a little more. Originally, it was 4 to 5%. But then with all that, slowly, we are galloping back to normalcy. So this is a time we should start deliberating on, spend more time on learning new things. And I'm sure that this Amendment Act 2020 will make things substantially easier and bring about, and also one more interesting thing is Section 140 has also been amended, where the penalty for auditors have been brought down from 5 lakhs to 2 lakhs and so on. So let us hear from the real expert, as they say. As the cliche goes, let's hear from the horse's own mouth and then be empowered on this new enactment or amended provisions of the Companies Act 2013. Thank you, Chairman. Thank you, Jose, all our managing committee members for the opportunity. I quite like every one of you. I'm also looking forward to hearing from Rao sir and wish the program all the success which it so richly deserves. And this is only a beginning. Sir would set the tone, and then we would have more sessions on this 2020 after probably the tax audit season. and we are fairly little more less tax worried and less tied up. Wish you all the very best. Thank you so much. Stay safe. Restraint, resilience, and resolve are what is required at this point of time. Thank you very much. All the very best to all of you. Thank you.
Thank you, Jagan sir, for your wonderful address, as always. So I'm very happy and I am privileged to introduce our speaker for this afternoon, Dr. P.V.S. Jagan Mohan Rao. He is a scholar with multiple qualification. You can see from the screen now, in a variety of disciplines ranging from commerce to astrology. He is a postgraduate in commerce, astrology, Sanskrit, LLB, FCS, FCMA, PhD, and MCJ, that is Master of Communication and Journalism. He has done his PhD on the subject Capital Markets from the School of Management Science, JNTU, Hyderabad. At present, he is practicing as an advocate in the High Court of Telangana, Hyderabad. He is the immediate past president of South Asian Federation of Accountants, SAFA, and now is an advisor to SAFA for the year 2020. He is a member of International Federation of Accountants. He is the past president of the Institute of Company Secretaries of India. He was the formal Central Council member for 9 years. He was the Central Council member at the Institute of Cost Accountants of India. He has held various positions as Director of Finance, Vice President Finance, and Company Secretary, Independent Directors, and also as members of the National Advisory Committee on Accounting Standards, Government of India, and member of Accounting Standards Board of CPE from 2001 to 2002. He also worked as a National Director with the Nandi Foundation, a premier NGO. He has been speaker in so many forums, including School of Business, State Bank Staff College, Administrative Staff College. He is also a frequent visitor to our institute also, ICAI and ICI, Institute of Chartered Cost Accountants, Institute of Company Secretaries, and Institute of Directors. And another his passion, green initiatives. He has addressed and published articles on climate change, environment, global warming, and sustainable development. He has taken up several green bicycle events and green walks, spreading the awareness on climate change, environment, and global warming, and sustainable development at several places in the country. He has published over 200 articles, stories, and poems in various magazines, including our journal, The Chartered Accountant, and other journals like The Management Accountant, the dailies, The Financial Express, Indian Express, Deccan Chronicle, etc., etc. And he has published a few books also, General Meetings, Company Secretary, Corporate Governance, and Bhagavad Gita, Company Secretaries, Corporate Governance, and Sundara Kanda, and Climate Change. So, with these words, I welcome sir to commence your session. Over to you, sir.
Ernakulam chapter of Ernakulam branch of the Institute of Chartered Accountants of India for very nicely introducing me, and expectations should not go up from me by or after introducing me. Anyway, let me see what best I can do. That is one part of it. Our CA Rai Varghese, Mr. Rai Varghese, he has very kindly invited me to the Ernakulam branch. I am very grateful to him. And Mr. CA Srinivasan, immediate past chairman of the Ernakulam branch. Last year, 2019, when I was the president of SAFA, I had an opportunity of coming to Ernakulam. Mr. Babu Abraham, CA Babu Abraham sir, who is a Central Council member now, I spoke to him in the morning. I said hello to him. He has invited me, and then I was there. We had a very excellent time, particularly with the students. Students program was very good. I had very excellent time with the students, very bright students from Cochin, the CA Institute. And of course, also the members meeting we did have at that time. I told to the president then and vice president then now, and Atul Gupta ji, who has become president now, and they were very happy to hear about these things. And I also would like to join Mr. Rai Varghese in wishing CA Joman K. George sir, who is the regional council member and immediate former chairman of the Southern India Regional Council of the ICAI, in wishing him to become the Central Council member soon. And we would like to see him as the president of the institute also. I would like to add that. And
Thank you so much.
you must become president of the institute. I'm very happy to see you here now and listen to your very wonderful speech that you have given, covering many aspects, not only just Companies Act, but also the development and the issues that we are facing because of the pandemic. Very nice, very short, sweet, and brief. That makes a person a chartered accountant and a former chairman, and who will become CCM and the president of the institute in the days to come. All the best to you, sir. Then Mr. Babu Abraham is not there now, but I spoke with him yesterday. And my greetings to all members and all fraternity of CA in Cochin. And then now coming to the subject, I would give you some introduction to start with, and then we will go deep into some of the sections, because as Mr. George has told, there are 66 sections actually in the Companies Amendment Act 2020. And in this 220 Act, the first section is the applicability of the Act, the first section. Out of 65 sections, 61 are amended. And then 4 sections have been, as we said, 4 sections have been introduced, including the section 378, which is the producer company, provisions relating to the producer company. We will discuss in detail, but it may not be possible for us to discuss all the sections. As I was going through after the even before it has been passed, or after it has been passed more seriously, a little more seriously into the each section, amended section and the concerned section in the Companies Act 2013. I feel we need to, if I just confine to only amendment, it will be only that reading a book, like reading a that section, like it won't suffice. So I will also try to share in some of the sections deep into what that section is. And then say for example section 128, 129A, and then 410, 418, these are very important for all the 3 professions. And some of the things have got impact on the IBC also. So we will share like that. And to start with Companies Amendment Act 2020, and this is the base act is Companies Act 2013. And we need to also understand the relevant rules, companies rules that have been framed for various chapters. The rules have been framed in 2014. And to understand any section, amended section, we need to understand the basic section in the Companies Act 2013, and also the concerned rules as per 2014 rules. Then basically how it has come, if you want to have a little 1 or 2 minutes brief into that, Company Law Committee was constituted in the month of September, 18th September 2019, to give recommendations. It was given a task of giving recommendations to decriminalize. One of the very important features is decriminalize some more provisions, some more that offenses. Actually, we had, as Mr. George mentioned, it has undergone amendments. So though it is 7 years now, it has undergone amendments in 2015, 2017, 2019, so on and so forth. And many circulars have come in between, clarifications have come. So all these amendments could not reach out to the expectations and that ease of doing business There were difficulties, actually, practical difficulties. So this committee was given the task of giving the recommendations. And then the committee has actually submitted the recommendations, giving certain relaxations, particularly in case of defaults, which can be determined objectively, and which otherwise lack any element of fraud. These are the few things we have to keep in mind, to where there is no intention of fraud. And then no, that do not involve large public interest also. There are some companies which are very small companies, like OPC, one-person company, small companies as per the definition, that 2 crore turnover, whatever. And then startup companies, now it have producer companies. There is no need to have that much of severe punishments or penalties. And they have gone through that, and they have given their recommendations. And after the recommendations have come from the committee, and based on the internal review by the Government of India, Ministry of Corporate Affairs, in consultation with various other stakeholders, the Companies Amendment Act 2020 was introduced in the Lok Sabha in the month of March 2020. March 2020, it has been introduced. Probably it might have been seen its own light immediately, but maybe because of pandemic, or we don't know. It has taken 6 months. 19 September 2020, it has been passed, and passed by Rajya Sabha on 22nd September 2020, and President assent has come on 28 September 2020. But why I am mentioning all these things is, though the notification has come as far as the Companies Amendment Act 2020, it has been passed, it is a legislation now. But at the same time, if you read the section 1 in the Companies Amendment Act, you will find that the provisions will be effective as may be appointed by the central government. Central government will appoint a date now, and then from that date onwards, each provision will come effective. And today, I think only 1 or 2 provisions have come, board or direct or something like that. But it is also given that different dates may be appointed for different provisions also. So they have not yet come into effective stage, many of the provisions. So that is the reason why I mentioned the date. And then, as I told you, we have 66 sections. Then, okay, this is one thing. Then to also share with you for the general understanding, amendment, see, if you want to see the amendments, if you can bifurcate and put into a kind of analysis of all the provisions that have been done, 61 plus 4, 65. So you can get into some kind of headings. That is, amendments related to ease of doing business. Say, for example, definition of listed company. Listed company definition is, I think, to section 2, subsection 52 defines what is a listed company. So that definition has been very rigid. See, in that, if you recall that, because all of us, the 3 professionals, we need to understand this section very deeply. Section 2, subsection 52 says, listed company means any of the securities listed on the stock exchange. Any of the securities means any company, securities of which they said securities. Securities means it includes debt securities, it includes equity securities. So equity shares, preference shares, debentures, bonds, so on and so forth, including convertible, non-convertible debentures. Even when you think in terms of a foreign fund providers, private equity, or venture capitalists, when they come here, they may give you capital in the form of a debt debenture, and then they insist that it must be recorded. If it is, it must be listed. So if it is listed, then even that company, though otherwise not listed, a small company, public limited company, taken the debt in the form of that debenture, and that as per the terms of conditions of the investment, that is listed, only the debenture portion. then it is listed. Then we have to comply with all the provisions in the Companies Act and all the applicable listing provisions. That is been liberalized now. Then this is one example for the ease of doing business. Then amendments related to ease of compliance. Whenever you think in terms of, there are certain provisions which say that you have to comply with many things, certain things as narrated, many things will be there in some provisions. So when you are supposed to comply with that, it must be easy. We should not expect, the companies and then, officers in the company spend all the time only for compliances. The compliances they are essential. There is no doubt about that. But it must be a kind of easy kind of a thing. Comfort is necessary. For that, if you want to give an example, section 16, rectification of name of the company. We will discuss in detail there. And then amendments, the third kind of that grouping of the amendments. Amendments related to further strengthening of corporate governance. There are certain things which strengthen the corporate governance. You need to do certain things. So how do you do that? So say for example, if I want to give an example for that, section 97, that 147, 140, 149, appointment of directors. If you think in terms of independent director is a very frequently used institution, the name of the institution in the context of corporate governance. But whenever independent director is appointed in any company, what is the remuneration that he is entitled to? These sections are amended, okay, 97 and 149. So now, how is he remunerated? He is remunerated in the form of fees, whatever fees as may be decided and approved by the shareholders. But general sitting fees is as per the law, it is defined there. So now whenever read with the rules, then whenever you think in terms of any other remuneration, he is entitled for remuneration other than the fees only as part of the percentage of the profits. And then he is not entitled for the ESOPs. Earlier he was entitled for the ESOPs. Now he is not entitled for the ESOPs. So now if the profits is not there, suppose the company is under losses or the profits are not adequate, inadequacy of profits, then independent director is not covered on that. Independent director will not get any money other than the fees, sitting fees or whatever. He will not get part of the profits because there are no profits. So naturally, how he will render services. So whenever any professional, a person of that repute joins your company as independent director, he must be paid properly also. There must be parity between the payment and the responsibilities they undertakes, because responsibilities for an independent director, if you read Schedule 4 in the Companies Act, you will understand, apart from all the sections, huge responsibility for the directors, the independent directors. And now, I see that if you recall the Schedule 5, Roman 5, in the Companies Act. In the Companies Act, we have 7 schedules. So Companies Act 2013. And in that, the Schedule 5 speaks about the remuneration. So remuneration, what does it speak about? You can pay minimum remuneration when the company is under losses or the profits are not adequate to pay the percentage or whatever defined for the remuneration purpose as per the terms and conditions. So now this was the issue for independent directors and also for the non-executive directors. So executive directors, independent directors, whole-time directors, these are the subjects we discuss when you think in terms of corporate governance. So now these things have been relaxed, and independent director and non-executive director are also covered under Schedule 5. Now, then another next thing is that there are certain amendments with respect to the winding up. These are all the broad bifurcation of the entire 65 sections. So then there are certain provisions which are related to the foreign companies. Companies incorporated outside India. When companies incorporated outside India, when they come to India, they are supposed to comply certain provisions. So when they are supposed to comply certain provisions, so it was very difficult in terms of certain things. And then now new section has been incorporated there that we will discuss there. That is related to the foreign companies. Then reduction in amount of penalty. as Mr. I think Mr. Joman K. George sir was mentioning, there are penalties, huge amount of penalty, large amounts of penalty, few lakhs of rupees, and it has been brought down now. That much amount, we don't know. Somehow it was introduced in Companies Act 2013 when the act has been drafted and passed. But now the difficulties are expressed and then faced. So now the Parliament has taken a view that the monetary penalties, it is not necessary to be at that high level, and they have been now reduced. That we will see. This is one bifurcation in the subheading. Then as Mr. George was mentioning, there are some provisions even calling for imprisonment. Even ordinary kind of defaults are subjected to the imprisonment. So these things, many provisions in these 61 sections, many of the provisions, many of the defaults have been done away with as far as the imprisonment is concerned. That is one thing. And penal provisions, some of the penal provisions have been completely removed in certain sections. And then there is one more important thing: compoundable and non-compoundable offences. There is a bifurcation that has been done better in certain sections now. This is another branching or categorization subheading. Then amendment relating to adjudication, compounding, etc. See that there are certain provisions which defaults of which you have to go to the NCLT, adjudicating officer, RD also adjudicating officer to some extent. So these authorities have to go. Now they have been reduced to the regular administration. So ROC, he himself can settle certain things. These are the I think that 7 or 8 or 9 subheadings that which I wanted to say that it goes like that. Then this is okay with. I think I've told you that producer companies. Producer companies is new. If you think in terms of what is producer company, see, in Companies Act 1956, it was not completely repealed till this 2020 amendment has come. So in the Companies Amendment Act 2020, there is a separate chapter that has been introduced now after 21A, that chapter has been introduced. And then this chapter completely contains about the producer companies. They wanted to bring a separate legislation, but ultimately they have decided let it be part of the Companies Act. So in that they have introduced, I think 43 or 44 sections they have introduced. And then these are all about the producer companies. Producer companies we will not be able to discuss now, but at the same time, let me see if I can give you some kind of idea on the producer companies. So then another important thing before I go deep into that, CSR is a very important provision, section 135. And that the relaxation there made is the liability. If your company, what is section 1? I think we will discuss when 135 comes. We will hold on that. And one more important thing that I would like to share with you at the time of introduction. Introduction itself will give you bird eye view of the entire Companies Act. So if somebody is busy and then they are not attending full kind of a discussion, still they get some idea about that. So whenever you think in terms of certain unlisted companies have been brought into the fold of compliances, and now they will be required. That some class of companies which will be required as may be decided. The word used is prescribed, as may be prescribed. Prescribed means always prescribed these rules. Always prescribe these rules specified by regulations, prescribed by the rules. Whenever we come across the word prescribed, it speaks about the rules. So the government of India will come out, in our case Ministry of Corporate Affairs will come out with the prescription, the rules where which class of companies will have to file the annual, periodical financial reports. They say that as per this provision, central government is empowered by 2020 Amendment Act that these unlisted companies will also have to file periodical financial statements as may be audited, or limited review, that will come in the notification. The rules it will carry that kind of information. And now this is I think expanded area of practice, because there is a large number of unlisted companies. Large number of, we have in our country about 14 lakh companies. In that, how many are listed? Not many, maybe 10,000 or something like that. So all non-listed companies are now brought into the fold of this review. Limited audit is anyway, it is there. Audit is there, annual audit is there. But now they will be required to give periodical financial statements, duly audited, or that limited audit review, whatever. See, that will be additional responsibility from the basic financial or statutory audit, whatever we call. This is important thing, that section we will discuss later. Another important thing, that so that you get the full fair idea about the Companies Act. If you recall the that NCLT formation, I was also actively involved in giving the information, that making some drafts, as to the NCLT in 2001, when I was the president of the CA Institute. So at that time, we were doing that, and when the government was completely planning to bring the NCLT into the picture, so that declogging of high courts, declogging of the judiciary can be addressed, so that the tribunals can be there, that adjudicating authority and the appellate authority, both the NCLT and NCLAT. But at that time, if you recall, we had that Madras Bar Association filed a case against the government of India. That was Madras Bar Association versus Union of India, and ultimately it went up to the Supreme Court, and then Supreme Court has is adjudicated, and then the Supreme Court has asked the government of India to do certain things ultimately before the NCLT comes. Government of India has agreed, and the NCLT has come into picture. Now, if you recall, maybe some of you or all of you might have read that the case lies Swiss Ribbons versus Union of India. If you have not read that case, please read that. You will find in the IBC cases, Insolvency and Bankruptcy Code 2016. In that cases, you will find that Swiss Ribbon case. Just go to the net and then Google. You will get that Swiss Ribbons versus Union of India. In that, many things have been challenged, and then the details we will discuss there. This is all what. And one more important thing, exemption from the filing resolutions extended to NBFCs. See, actually, certain resolutions, banking companies are not required to file under 17 or something, so they are not required to file. But NBFCs, these companies, they were required to file, because every day, many times in a day, even you sanction the loans, and then you may have to file the resolutions. It will be difficult for the banking companies. So banking companies, anyway, they were not brought under the picture. But now NBFCs also almost like banking companies, isn't it? So the HFCs and NBFCs are also given that kind of exemption in the current scenario. So we will go through that. Yes, exclusion of certain companies, from the definition of listed company, which I have told you. So I will take up in detail. So I have already mentioned to you what is this about. In nutshell, listed company means a company which has any of its securities listed on any recognized stock exchange. So now the following proviso shall be inserted. Now what happened? Any securities that were there in any securities were there in the 2013 Basic Companies Act. In the Amendment Act, it is introduced like this. The following proviso shall be introduced, provided that such class of companies which have listed or intended to list such class of securities as may be prescribed in consultation with the SEBI shall not be considered as a listed companies. So how do you analyze this amendment? So Parliament has empowered the government of India to exempt or treat those securities or those class of companies not to be listed. So the first thing is that such class of companies, Government of India may classify certain companies from out of this definition of securities, and also such class of security, such class of companies, number one, such class of securities is number two. These two categories, as may be prescribed by the Government of India, will be exempt. And the Government of India cannot do on its own. It has to make consultations with the SEBI, and then they will make this addition. Say, for example, as I told you, companies which list only debt securities may be excluded. So if the companies are having only listed for their debt securities, debentures, or if it is convertible debentures, that is different. It should be non-convertible debentures. Then it will be treated as not listed under section 2 subsection 52 of the Companies Act. This is the first amendment. Then section 8. What is section 8? And many of you might have incorporated section 8, maybe the auditors of section 8. Section 8 company is basically called as section 25 company in the Companies Act 1956. So it is called as non-profit organization. So it is whenever anybody applies to the central government and the central government is satisfied, then the central government will give license. This is called as a license under section 8. When it is proposed to be registered as under this act as a limited company, has in its objects promotion of commerce, arts, science, sports, education, research, social welfare, religion, clarity, protection of environment, any such other related social objective you can have, and it intends to apply its profits in promoting its objects. Again, whenever you think in terms of section 8 company, it cannot distribute dividends to the members. So it has to utilize for the purpose of the objectives of the company only. Then the central government may give a license with such conditions as may be prescribed. It can be, see that again, section 8 company, because many of our friends, chartered accountants or CS, mostly chartered accountant CS, they sometimes they have asked me whether section 8 company can be private company or public limited. It can be either private limited company or public limited. Can one person company be private limited company or public limited company? You think about and ask me if you are not aware of that. Then this the only thing that whenever you think in terms of one or two more points as far as section 8 companies, whenever it is a section 8 company, it may get several relaxations from the municipal authorities and the state governments as to the land, as to supply of many things, even tax concessions they may get. So whenever you have section 8 company, it is looked at from that public angle, serious angle. That is the reason why how do you amend memorandum and articles of association of any company? Memorandum and articles of association of any company can be amended by a special resolution, simple, by a special resolution, giving a special notice under section 101 of the Companies Act, and then give those details, comply with the secretarial things, and then as per the rules, you can amend the any provision, you can amend any provision in the articles or memorandum by passing a special resolution, because this is completely given to the will and desire of members, that's all. But in case of section 8 company, it cannot be done like that, and it needs to be approved by the central government. And then alteration of memorandum, I told you that revoke the license, the central government may revoke the license whenever it finds that it is not complying with the provisions of the license or the Companies Act or the in the public interest. So now winding up, I think we need not go here, but at the same time to share with you, because we have touched upon the section 8, this company can be merged with another section 8 company, and then it may be converted into non-section 8 company also, that we will not discuss now. And if a company is wound up, section 8 company is winding up, in case of winding up, what will happen? In case of winding up, whatever property or assets there in that company may be transferred to similar kind of Section 8 company. Or if there is any amounts remain, property remain, the amounts are not, that not distributed, that is there. Then the amounts will have to be transferred to the insolvency and bankruptcy code, that there is a separate fund under IBC, that insolvency and bankruptcy fund. So you have to transfer to that. So now the defaults and the amendment that has come. If defaults, the old provision, what are the old provisions as far as Section 8 is concerned? A company 10 lakhs to 1 crore. Company, if any of the provisions of Section 8 or the Companies Act are not complied with, the penalty is minimum 10 lakhs and the maximum 1 crore. And this is the company, old provision. Then director, officer, any person who is an officer of the company who is in default, he will be responsible for a fine of 25,000 rupees to 25 lakhs. This is what Mr. George was mentioning in the liberalization. See that 25,000 to 25 lakhs, see the range. This is for the for an officer who is in default in Section 8. Then now, and if there is any fraud, apart from this this imprisonment of 3 years, see that in case of am I clear? In case of a company, non-compliance of Section 8 provisions, the minimum penalty is 10 lakhs and maximum 1 crore in the case of a company. And director or officer who is in default, he will have to pay 25,000 rupees up to 25 lakhs maximum. And the punishment, that imprisonment is up to 3 years. This is what old provisions, earlier provisions, are with both. For the officer who is in default, it may be 25,000 to 25 lakhs and also imprisonment up to 3 years. So now, if there is any fraud, again that fraud section is there now. What is the Section 447? Section 447. All of us must read 447 very thoroughly. 447 speaks about the frauds. So if there is any, that fraud kind of a thing, apart from Section 8 compliance, the penalty which I mentioned to you, they will be also subjected to prosecution or penalties under Section 447. So now, new provision. There is the first thing is that director, the company will be only 10 lakhs to 1 crore. 10 lakhs to 1 crore. Then the company amount has been reduced to 10 lakhs to 1 crore. Then director and every officer of the company who is in default shall be punishable. Minimum 25,000 rupees, maximum 25 lakhs. The monetary portion as to the director and officer who is in default has been retained, 25,000 to 25 lakhs, but the 3-year imprisonment completely removed. So this is decriminalization completely as far as Section 8 is concerned. So now I will take you to the another provision. Section 8 is done. Change of name of a company. So how do we deal with change of name of company under Section 16? Section 16, if you recall, a company will get the name after after you have applied to the central government, that you propose one name, whatever 3 names you propose, and then the central government MCA will give you the name. After name is selected, there are several guidelines in sanctioning a name. That rules I am not mentioning now, rules and guidelines. So as per those rules and guidelines, a name is allotted to you when you are a promoter, and then you can have that name and incorporate that name. But whenever there is any mistake, inadvertence in giving you that name by the central government, then what will happen? That is one issue. The second thing is that whenever you want to change the name after the company has been incorporated with the name that government has given you, you can change the name anytime by a special resolution. And at that time also you have to go to the central government and ask for the new proposed name, and they will give you. And whenever you see, there is another instance, whenever you have incorporated a name there may be by inadvertence, you have been given a particular name by the central government, by inadvertence, number one. Number two, your company name may be resembling any trademark. If the company's name is resembling any trademark, it has been registered in that name, and Ministry of Corporate Affairs may not be knowing the trademarks angle sometimes. So then it is to the trademark registered owner of the particular trademark to complain that, and then that has to be done. Hopefully, I am able to reach out to you, Mr. Varghese, Rai Varghese sir. I am able to reach out to you.
Yes, sir. Yes, sir.
Sir, yes, we can hear you.
So now, see, now whenever you think in terms of that, the name that has been given, and it resembles a trademark, and then the trademark registered owner can complain, and it has to be done within 3 years. And if it is done like that, then the government will tell to the company, you please change the name, and the company is required to change the name. And the company doesn't change the name, it leads to the default, and then compliances, and then prosecution and whatever. So now in this process, I'll tell you, is identical with or too nearly resembles the name of any existing or registered company under this act or any earlier act also. Any company registered under this 2013 legislation or any 1956, 2013, sorry, 1913, 1935, any of the previous company legislations. Then the government may direct them to do it. And then the company will have to change. When the direction comes from the government, the company will have to change within 3 months. And then it is by an ordinary resolution and not by a special resolution. Then that this is section 16, 16(1)(a), 1(b). 1(a) speaks about the general similarity of the name. Section B speaks about the trademark instances. So whenever it has been done, now you see the trademarks, in the case of trademarks are the change, the government will give a direction to the company to change. In this case, it is 6 months. 6 months have been prescribed to change the name within. And now the change is that the company will have to change the name within 3 months. This is the amendment here. The company will have to, after receiving direction from the government of India, the company will have to change the name within 3 months. And if it doesn't change, what happens? The company doesn't change. The new amendment is the government of India will allot you a name, Mr. Varghese. The government of India will allot to your company a name, whatever name they want, as per their that procedures. They will allot you a name, and they are not only allotting you a name without receiving any communication from you after 3 months. Or they will incorporate the company in the new name. Then you see, it will incorporate Government of India, ROC, Register of Companies, will incorporate the company in a new name as may be selected by is it okay?
Yes.
So as may be selected by the ROC, and then the company will have to be will have to be called by that name. You don't have any option if you don't do it within 3 months. But what option is there? You can change the name after the government changes the name to whatever name you want in your normal process, that you get the name that you want and you pass a special resolution in the members meeting and you can pass. This is how. So now the default in companies, the directions of the company government. If there is any default in the case of directions given by the company and the company has not complied with that, so it has new name, and the default is complying directions. I told you that 5,000 rupees to 1 lakh. 5,000 rupees to 1 lakh. So now, special resolution. Okay, so now this is also done with approval. CGA, central government, you will take that. Then we will take another next section. Section 23, public offer and private placement, allowing certain companies to list a class of securities in foreign other jurisdictions, power to central government to exempt from various provisions of the legislation. So section 23, if you recall section 23, and then this comes under part 3, Roman part 3. How many parts we have in the Companies Act? 29 parts we have. So whenever you think in terms of public issues, IPOs or FPOs, initial public offer or follow-on public offer. So these kinds of issues are dealt under chapter 3. So now then in the chapter 3 there are 2 parts, part 1 and part 2. So the prospectus and allotment of securities, that is part 1, section 23. And now there were only 2 sections earlier. The amended act has added 2 more sections. So now we have 4 sections there. So now a company, you have a company. What are all the ways that you can raise money from public? What are all the ways? What are all the types of shares that you can raise? The first thing is public offer. Second thing is private placement. Public offer means you are going to the public and then public will subscribe. Large number of shareholders will come. Private placement means you are privately placing without going to the public, and then as per the norms, the compliance, you raise the money through private placement. Then apart from public offer and private placement, there are 2 more things. What are these? Bonus issues and rights issues. So rights issue means what? A rights issue means in case anytime any company after incorporating, if it wants to raise money, the offer must be first given to the existing shareholders. This is called the rights issue. So then what is the bonus issue? Bonus issue is without taking any amounts of proceeds from the public, they are given bonus at a particular ratio as per the Companies Act guidelines and also as per the Companies Act provisions and the SEBI guidelines. So this is for the public limited companies. What about the private limited companies? Private limited companies, by definition, they cannot offer shares to the public. They cannot raise money from the public. Therefore, the private limited companies have got only direct rights issue and bonus shares, and then private placement is permitted, and then rights issue is permitted. But you cannot go only public. You cannot go to the public for raising the money. Now, you see that 2 sections I have told you that they have introduced in the Companies Amendment Act 2020 as to section 23 of the Companies Act. So section 23, 1 and 2 I have already told you. Then 3 and 4 now they have introduced. What are that they have introduced? Section 23 subsection 3 which they have introduced reads like this. Such class of public companies may issue such class of securities. Such class of public companies may issue such class of securities for the purpose of listing on permitted stock exchanges in permissible foreign jurisdictions or other jurisdictions as may be prescribed, as may be provided by rules by the central government. So 23(3) new inclusion says that these companies may directly issue shares to the people, and then these can be listed on the specified, as may be specified, as may be prescribed by the rules. So section 23 subsection 3 empowers the central government to classify certain companies and certain securities, to issue the shares and these companies, these securities can be listed on the foreign stock exchanges in foreign jurisdictions or in certain jurisdictions, they said. We will see the details when they come, if they have not yet been formed. Rules have not yet been formed. This is section 23.3. So what is the amendment? Companies can directly list in foreign companies, certain class of companies, certain securities of certain companies. So already I have seen a news item in Financial Express 4 days back. London Stock Exchange. London Stock Exchange already started wooing the Indian companies to come to their stock exchange and list directly, and then have these listed, so that their businesses can be expanded. It is a welcome feature for our company also. This is how we get into the ease of doing business. So then you see that there are certain companies. I will tell you in one or two sentences. The central government may by notification, this is another power given to the central government by the parliament through this 2020 Amendment Act. The central government may by notification exempt any class or classes of public companies referred to in the above section 23.3, which I told you already. From the provisions of chapter 3 and chapter 4. Chapter 3 I told you, that is the prospectus and allotment of securities. Then chapter 4 speaks about share capital and debentures. If you go deep into these two chapters, chapter 3 and chapter 4 of part 3, and then chapter 3 and chapter 4 main chapters, you have two things: prospectus and allotment of securities, share capital and debentures. There are many compliances. Now the central government is empowered to exempt these class of companies or a class of securities which are being permitted to directly list in the exchanges in the foreign jurisdictions. Company has got power to exempt, and there are three more sections also which will be exempted for these companies as per the rules that will be prescribed in due course. Then what are those other things? Section 89, declaration in respect of beneficial interest in any shares. Section 89 is section 88, 89, 90, these are very important things. There are certain amendments in that also I will try to cover. So now the point is, central government can now exempt these permitted companies to when they are going to be listed on the foreign stock exchanges from section 89, declaration of beneficial interest. They will be exempted. Section 90, register of significant beneficial owners in a company. I think as chartered accountants, all of you must have come across the two sections heavily. And then whenever you are dealing with your audit also, you are required to check up in detail about the compliance of section 89, section 90. That is declaration of beneficial interest, and also that is the register that needs to be maintained for the purpose of beneficial owners in the company. Then there is another section 127. If you read section 127, you will understand that is dividend. Whenever you think in terms of dividend, there are many that compliances, that the dividend has to be declared within 30 days, it has to be paid. After that, within some time, you have to transfer it to the that unpaid dividend account. After some time, you have to transfer to the central government investor protection fund, and in between, whatever compliances are required. So all these provisions also will be exempted for those companies which may be listed on the foreign jurisdictions. These are the three sections. So what are all the exemptions that have been provided under section 23.4 now in the new amendment? That these companies will be exempted from chapter 3, chapter 4, section 89, 90 and 127. This is the amendment to the section 23. Then I will take you to see here this is another important thing which we have to also see in detail a little. Section 62. I have just now told you about the section 23 part 3. I have told you that is rights shares, right shares. Further issue of shares means right shares only. So whenever you think in terms of these further issue of shares, which we call them as rights issues, how do you actually, there is an amendment here in this section. How do you handle these right issues? See, when at any time, any given point of time, the company wants to raise the share capital, it wants to increase its subscribed share capital by issue of further shares. Such shares shall be first offered to the persons at the date of on the date of the offer to the holders of equity shares. Please remember, right shares is only for equity shares. So you have to offer to the existing equity shareholders in proportion of their paid up capital. This is one important thing we have to note that. It is not that how many shares they have subscribed, how much they have paid on subscription. It is on the basis of paid up capital. If you go deep into that, you have to check up when you go for the audit also. The point is that a share may be face value of 10 rupees. Then at the subscription time, they might have asked only 5 rupees. And large number of shareholders might have paid an entire 10 rupees when it is called upon, or they are stuck up at first 5 rupees. But at that point of time, if you are coming for the rights issue, it is not on the share number you will offer, but it is also on the basis of the paid up share capital. You must remember that. Then the company will have to send a letter of offer to every shareholder who is entitled to have this share. And then you have to write in that letter specific number of shares that you're offering, because as I told you, somebody holding 100 shares may get less, somebody holding another holding but the same number of 100 shares, if the paid up capital is more, he will get more. So specify the number. And another important point here is, you will ask as per section 62, you are required to ask the person who is an existing shareholder whom you are offering rights issue now, you have to give him some time. That time prescribed is 15 days to 30 days. Minimum 15 days and maximum 30 days time is given to the existing shareholder to apply for the rights or to renounce. So you have to write in your letter also about the renunciation. So you have to tell him that you can apply if you want to, or you can also renounce your right to whomever you want. He may not be the person, the renouncee need not be member of the company. So he can apply as at his will and desire, and then that has to be done. You have to give some specific time, has to be specified, 15 days to 30 days. Unless article basis, they will be right to renounce. You see, a renunciation is as per the articles. If your articles restrict on the renunciation, that will be subject to those kind of things. But only thing is that whenever you think in terms of that, you can offer otherwise than to the existing shareholders by passing a special resolution. And whenever you are giving ESOPs, say for example, you are giving ESOPs to employees, the ESOPs employees may not be shareholders also. That also you can do that by authority of a special resolution. Then nothing in this section shall apply to increase of the subscribed capital. Okay, when government and then another important thing what you need to note here is you will have to understand one important thing. So I'm trying to share with you some of these sections, it deep into the company side, then come to the amendments also, so that you will have compact knowledge, compact exposure on the certain sections. It may not be possible for us to complete the entire thing. I may mention just like that, but deep involvement, I am taking certain sections which that all of you as an auditor, as a chartered accountant, will have to do that as it goes by during your course of assignments. So now another important thing that you may come across is, if central government has given you any loan to your company, if central government has given you any loan, and if the loan is not repaid, or the government wants that this loan should be converted into equity shares at its own will, government has got that power. and it may be compulsion also. And the god, but it must, they will have to go through certain procedures. It must be in the public interest, so on and so forth. Then after they are satisfied, the government, after government is satisfied, they can direct the company to convert the loan into equity shares. And if you are not happy with that kind of direction, you can go to the NCLT. NCLT will decide about that, and NCLT will have to, the appeal has to be made within 60 days to NCLT, and then NCLT also will have to do it in a time framed kind of a thing. I'm not going into details of that. So now, what is the amendment here? Amendment in the Companies Amendment Act 2020 is, as far as this section 60, 61, this section 60, 62 is the rights issue. 62 is concerned. I told you the company will have to offer to the existing shareholders, fine, and you have to give them time 15 days to 30 days. So minimum 15 days gap has come, isn't it? Sometimes that much gap may not be required. Funds may be required immediately to the companies. This issue has been addressed by the Parliament, and in the Companies Amendment Act, it has been prescribed now. The company, it has been the power to central government. Parliament has given through this amendment power to central government to reduce the time of 15 days to whatever time they may feel appropriate. Rules will have to come. So in that case, what happens if they prescribe 5 days, 6 days, 3 days or whatever, then the entire 15 days will come down and the companies will get monies very quickly. And then this is definitely in the context of ease of doing business, and then that good corporate governance also quickly it will happen. Okay. This is one thing I would like to discuss a little deep. You see that a power of company to purchase its own securities. This is the 68. No, not 68. I would not like to go now. Yes, register of members. This is another thing. As an auditor, I am sure naturally wherever you carry on the audit, you will definitely go through the members register and compliance thereof. Though you have secretarial audit, though there may be company secretary in the company, but as an auditor, statutory auditor, it is good that if you go through the provisions of the compliance of provisions with regard to the register of members, because that is the basic thing that company will be that will be based upon the ownership, the beneficial interest, so on and so forth. So what is the register of members? Register of members is maintained under section 88 of the Companies. Then whenever you think in terms of register of members, what is the register of companies? You may come across that doubt. What is the register of companies? Register of companies is under section 2 subsection 74. So 274, section 2 subsection 74 speaks about the register of companies. Register of companies is maintained by the registrar of companies. ROC maintains register of companies where all the companies registered in that particular state, because ROC is for every state. So whenever you have this kind of register of companies, ROC will maintain that immediately after the incorporation of such companies. So now little details into section 88. Every company shall keep and maintain in such form and such manner as may be prescribed. They are not prescribed actually, okay, already prescribed. Companies, that where are they prescribed? How do you maintain the register of members? It is to be maintained as per the company's management and administration rules 2014. Companies management and administration rules 2014. Basically, you also need to go through a little carefully about the rules, certain rules, say 3, 4, 5, 8, and 25 of this set of rules. Then register of members, what are all the registers that you have to maintain? Register of members, register of debenture holders, Register of any other securities also you have to maintain. And then not only the register, but you have to maintain also the index of each type of securities. The register can be maintained, that either in the electronic form or the physical form as per the rules. Then your company also can maintain a foreign register wherever you have that kind of shareholders as per the articles, and then you can comply with those provisions. The company does not maintain. Suppose you are not maintained your register as per section 88. What are the penalties? The old penalty was earlier, before 2020 Amendment Act has come, it was 50,000 rupees to 3 lakhs. 50,000 rupees to 3 lakhs if any default is there as to section 88. 50,000 rupees to 3 lakhs and plus 1,000 rupees per day of default from the day of first default till the compliance is made. 1,000 rupees per day, subject to 50,000 minimum, maximum 3 lakhs of rupees. So and this 50,000 3 lakhs are, please be very careful, 50,000 rupees to 3 lakhs or 1,000 per day for the company and every officer who is in default. Double. Every officer in default also will have to be subjected to this kind of penalties. Now the company's Amendment Act 2020 has changed this. What is the new provision? New provision is company 3 lakhs. It is not 50,000 rupees 3 lakhs. It is 3 lakhs. That's all. And every officer of the company 50,000 rupees. That per day 1,000 rupees is done away with. This is the change in that section. Next 88. After that 89. This is a very important section, and every auditor must definitely go through this section. Section 89. Declaration in respect of beneficial interest in any in any share. Declaration of respect of beneficial interest in any share. So how do you basically, if you want to understand in nutshell about this section and provision, this section and provision, if you want to understand, see, we have time up to 5 o'clock now.
Yes, sir.
Okay.
5 o'clock. Yes.
Okay. So now you see, whenever you think in terms of this particular section, what is beneficial interest? Suppose I am a shareholder. My name is registered in the register of members, as I told you earlier provision we have discussed. So whenever that kind of name is registered, he is the registered shareholder. So when I have shares registered on my name, I may not be the ultimate beneficiary. There may be somebody else who is the beneficial owner. So in this case, as a beneficial owner, he has to give notice to the company. I, as a registered owner, I have to give, and the company in turn will have to file with the registrar of companies. These are the 3 compliances. Such person called the registered owner as per Rule 9. You have to refer to the Management and Administration Rules 2014, and the form fixed is MGT 4 to MGT 6. You go through that. And then within 30 days from the date of entry in the register, you have to give the details. And he should specify the name of the person who holds the beneficial interest also. When I'm a registered owner, I have to specify who is the beneficial owner. And also a person who holds the beneficial interest, as I told you, he also will have to comply with that. And the company also will have to, whenever will have to register, will have to file with the registrar of companies. And the registered owner and the beneficial owner it has to be done within 30 days. It has to be done within 30 days. And now if any of these provisions are not complied with, what will happen? I think I will not go deep into that. Okay, I'll just take the penalty, and these are the basic things, and the penalty will be, old penalty was 50,000 rupees plus 1,000 per day. 50,000 rupees plus 1,000 per day. The registered owner and the beneficial owner and the company. The amendment 2020 says that 50,000 rupees plus 200, maximum of 5 lakhs. Earlier there was no maximum. If it is 1,000 rupees, 365 days, that much amount comes. But now it is 3 years, per year like that. So if it is now only 50,000 rupees plus 200, then the maximum penalty also is put at 5 lakhs. After receiving such information, I think we will skip this. Then I will take you to the next one. Register of significant beneficial owners in the company. So you see, this is earlier you have to disclose about the beneficial holding. Who is the beneficiary? Who is the registered shareholder? That is okay. But this section 90 speaks about every individual who alone or together. Every individual alone or together with one or more persons, and it may be including trust also, together, whether residing in India or outside, and you hold not less than 25% or such other percentage as may be prescribed by the rules, you have to file with the company BEN 1 as per the company's significant beneficial interest rules, BEN 1. That has to be done within 30 days of your acquiring the beneficial interest to that extent of 25% in the company. And then you have to intimate to the company, and the company can, I think I will rush it through. Penalty. The penalty in the whole penalty was minimum 1 lakh, maximum 10 lakhs. Minimum 1 lakh and maximum 10 lakhs plus 1,000 rupees per day. And then the new penalty is 50,000 rupees plus 1,000 per day, subject to maximum 2 lakhs. So 1 lakh to 10 lakhs has been reduced to 50,000 rupees to 2 lakhs. 50,000 rupees to maximum 2 lakhs, though it is 1,000 per day. So now register denies inspection. See that again, the company has to provide inspection for anybody, any shareholder wants to see the benefit, this beneficial owners register. The company will have to permit them during office hours at least for 2 hours per day. Then again there is a huge penalty that was prescribed. It was actually are you clear about that? The penalty that is now prescribed if the company fails to provide the inspection. Earlier penalty was 10 lakhs with a maximum of 50 lakhs. 10 lakhs minimum and maximum 50 lakhs if you deny the permission to the shareholder, plus 1,000 per day. And every officer of the company, 10 lakhs to 50 lakhs plus 1,000. Imagine if any company if any company denies the inspection, then every officer of the company will be subjected to a penalty of 10 lakhs to 50 lakhs. And per day 1,000 rupees. Huge penalty, isn't it? Now the new amendment. The amendment has brought in, and the new penalty is the company, it is 1 lakh plus 500 per day, maximum of 5 lakhs. So it has come down to 5 lakhs. From 50 lakhs, it has come down to 5 lakhs, that maximum amount. And then every officer also it was 50 lakhs earlier. Now penalty of only 25,000 rupees. 50 lakhs has come down to 25,000. So 25,000 plus 200 rupees per day. It was 1,000 rupees per day, subject to there was no subject. 1,000 rupees per day. Now it is 200 rupees per day, subject to a maximum of 1 lakh. This is about this section, and then we will see. Okay, this is also important. Unpaid dividend account. You see, dividend account. I was telling you in the beginning. As far as the dividend account is concerned, it has to be distributed within 30 days. We have noted. And then after 30 days, within 7 days, you have to transfer to a scheduled bank account in the name of unpaid dividend account of that company. You have to give the details, names, addresses, and so on and so forth. And if any amount still remains unpaid for a period of 7 years, and after that 7 years, we have to transfer it to the Investor Education Protection Fund, along with the statement of all the particulars of that. Then if you don't do that, what happens? Penalty, old penalty was 5 lakhs to 25 lakhs. Old penalty if you don't comply with the section 124, that is unpaid dividend account. If you are not complying with the payment of dividend account provisions that are prescribed in section 124, you need to, rather you are subjected to, if the default is there, if there is any default, you are subjected to penalty of old penalty, that is 5 lakhs to 25 lakhs. Every officer was subjected to 1 lakh to minimum 1 lakh, maximum 5 lakhs. What is the new provision? There is an amendment. In the new provision, that 5 lakhs, new provision, you understand in two things. First, by the company. Company earlier was 5 lakhs. It has been brought to 1 lakh. And then maximum it was 25 lakhs. Now it has brought down to 10 lakhs. And per day 500 rupees it has been prescribed now. So 1 lakh plus 500 rupees per day, maximum of 10 lakhs. So 5 lakhs 25 has become 1 lakh and 10 lakhs. So every officer who is in default, it was 1 lakh minimum, 5 lakhs was the maximum. Now that has come down to 25,000 rupees minimum, from 1 lakh to 100 rupees per day, not more than 2 lakhs. 5 lakhs has been brought down to 2 lakhs. This is another important thing for all of us, secretaries, CMAs and chartered accountants, definitely. This speaks about section 128 in chapter 9. As all of us are aware, chapter 9, Roman 9, in the Companies Act speaks about the books of accounts. So this chapter has got, I think, 10 sections. Section 128 to 138, 11 sections. Section 128 to 138. All of us must read this section. I am sure that all of you must have read this section. Then accounts of companies, if there is any default, who will be held responsible in the company? Whole-time director and in charge of, any person who is in charge of the accounts, whole-time director, finance director, and also CFO, sir, not CEO, whole-time director, director finance, and then CFO, or any person who is charged with the compliance of these provisions of the Companies Act by the board. These persons are responsible for the filing and compliance of chapter 9. And if I'm not discussing about those things, it is it is very difficult to discuss. Section 134 is a huge kind of a even I can tell you, even section 128 it takes minimum 3 hours. If you include 134, which is part of this chapter, only 134, section 134, you can discuss for more than 10 hours. But I am telling you in a nutshell, the responsibility of these officers whom I told you, director and CFO, the penalty, if you are not complied with what you are supposed to comply under section 128, books are not prepared properly, so on and so forth. So the earlier penalty was imprisonment of 1 year, director finance or CFO, imprisonment of 1 year, or with fine of 50,000, 5 lakhs, or with both. So if 128 is violated, earlier provision was imprisonment of 1 year and then penalty of 50,000 rupees or 5 lakhs of 5 lakhs of rupees. So imprisonment of 1 year, penalty of 50,000 rupees to the maximum of 5 lakhs, or with both. So that has been amended now. It's a beautiful amendment, I can tell you. The imprisonment, new amendment in the Companies Act 2020, new default penalties are, first thing, imprisonment is removed, and then 50,000 rupees to 5 lakhs, that remains. Okay, it is only monetary penalty, decriminalized. Okay, section 129. Yes, this is, as I told you, 4 sections have been introduced. Section 129A is one of those 4 sections. So now section inserted, this is, we can say, for the good corporate governance or whatever. And that central government is now empowered. The basic thing I told you in the beginning. So the central government is now empowered per the 2020 Amendment Act, Companies Amendment Act 2020, to notify through the rules and regulations, and then they can come out with that kind of provisions that a company, certain class of companies, it reads perhaps somewhere something like this, 129A. What is that? Such class or class of unlimited companies will be required now to provide periodical financial results of the company, audit or limited review, and then file with the registrar of companies within 30 days from that periodic time limits that will be provided in the prescription or the rules by the central government. This is about 129A. Is a additional area of practice for the chartered accountants. Then this is another important provision which I was mentioning you, section 134, financial statement and board's report. This is a very, very beautiful section. All of us must be completely aware of section 130. It's a very, very important section. So what are the basic things if you want to know about this? Financial statements, including consolidated financial statement wherever it is there, shall be approved by the board of directors. And when they are approved by the board of directors, authentication under section 134(1), which is very important. So whenever you think, if students are attending this session, I suggest all of them must read very thoroughly section 134. So 134 says that after the financial statements are approved by the board of directors, they will have to be authenticated. Authenticated means what? Some people as authorized will have to sign the documents which are approved by the board of directors, and after approval of that, after approval of those financial statements, after such approval, and after they have been authenticated by the authorized people, then only auditors will take these documents. All of you, the chartered accountants, the auditors of the company, you will take the documents only after they have been authenticated before that approved by the board of directors. When you have that authenticated documents, financial statement, profit and loss account, balance sheet, or whatever the set of documents, you will take that and then you will start your audit. Therefore, in my view, audit starts only after accounts end. Accounts end means you will get the final statement of profit and loss account and balance sheet, the financial statement under section 128 of the Companies Act, only after they are approved by the board of directors and authenticated and given to you. Till then, you didn't have any complete final approved document. So you can actually say you have got the document now, you have got the share capital in that, certain sales are there, all the monies that have come through the investment or the revenue. So you will check back. Suppose profit and loss account, balance sheet, they say this much amount has come. You will trace back to the primary books of entry and then cash and bank balances. So this is how probably audit is done. So audit starts only accounts are done. Accounts are completed and authenticated. This is important. 134(1). The auditor's report to be attached to the financial statements. We are aware of that. Board of Directors report 134 section 134 subsection 3 is very, very important. We must know it is very, very important. It is all about the board report. The board report, I don't have much time to tell you now, but to go through very quickly, the number of board meetings held and the declaration by the independent directors responsibility statement, and section 134 subsection 5 clause E and clause F. If any one of you would like to make a note of that, please make section 134 subsection 5 clause E and F. These are very important things. Now that is called internal financial control systems. And then internal, that legal compliances kind of a thing that has to be made by the company. and board of directors in every meeting, they have to ensure that these things are properly checked. And conservation of energy, okay, these are all the things, okay. And then OPC company abridged kind of a thing, we are aware of that. Board, and before that, authentication. When you think in terms of authentication, who can sign the authentication? If chairman is approved, he can sign, or if chairman is not approved, any two directors plus CEO minimum two directors, including MD, wherever MD is there, plus CEO, Chief Executive Officer, plus the Chief Finance Officer, and the company secretary will have to sign. And after that, it is sent to the auditors. You should not, as an auditor, you should not take unless and until these people have signed it. Board report shall be signed by, then board report. This is about the financial statement. Then 134(6) speaks about the board report. Board report also will have to be signed at least by two directors. That we will not go deep into that. Then if any of the provisions of section 134, this is the amendment, section 134 is not complied with, what will happen? The old penalty was minimum of 50,000 rupees. This is a very important provision for all of us. Old provisions, if you don't comply with section 134, that is accounts and board report, financial statements and board of directors report. If any provision is not complied with, the company will have to pay 50,000 rupees minimum penalty and maximum 25 lakhs. And every officer of the company will be subjected to imprisonment up to 3 years and penalty of 50,000 rupees to 5 lakhs. This is the old provision. What was the old provision? For the company, minimum 50,000 to 25,000, sorry, minimum 50,000 to maximum 25 lakhs penalty. And then officer who is in, every officer who is in default, please note that, not one officer. Every officer who is in default will be subjected to imprisonment up to 3 years and penalty of 50,000 rupees minimum, maximum 5 lakhs. This is gone. And what has come in now? New penalty, company and officer, either of them, company will have to pay, officer who is in default also has to pay. That both of them will have to pay only penalty and imprisonment is gone. So the company's penalty now required is 3 lakhs. From that 50,000 to 25 lakhs, non-compliance of section 134, it has brought down to 3 lakhs. And officer who is in default, 3 years gone imprisonment, 50,000 to 5 lakhs has gone. Now maximum, the amount of penalty is 50,000 only. This is about section 134. Then the corporate social responsibility. See, whenever you think in terms of CSR, we are aware of that. Any company which has got 1,000 crores turnover, 500 crores net worth, or 5 crore profit, these companies, including private limited companies, these companies will be subjected to spend not less than 2%. It is 2% prescribed, 2% on an average 3 years profits of the net profits of the company. So now if these things have not been complied with, the stringent provisions were there yesterday, earlier in the earlier Companies Act, and the changes that has been made is that if your company is the amount, see the 2% calculated amount, if it is 50 lakhs, you don't need to form a committee. So as per section 135, the threshold limit we are aware. If you are coming under the threshold limit, you need to form a separate CSR committee. But now the exemption is, if your spendable amount, the 2% comes to 50 lakhs and below, you don't need to have any separate committee. That is one relaxation. Then another relaxation is that if you spend any money beyond 2% now, in this year, if you spend some money for any project on CSR, you spend money beyond what is required to be spent as per 2% this year, then that can be transferred to the subsequent years. This is one provision. This we will see later. You must have been aware of that. This is one very important thing. 143. See that if you think in terms of 143 powers and duties of auditors and auditing standards, in that, if you recall 143.12 subsection 12 of section 143, we are aware that that section speaks about the frauds or no likely frauds or whatever. So the auditor will have to, auditor means all the three, the financial auditor and cost auditor and the secretarial auditor. These auditors will have to report to the board of directors and then to the that Government of India Secretary Corporate Affairs. Whenever there are that deviations from the thing, or that frauds are taking place or likely to take place, and if they are not taken place, there are penalties. I will take up only penalty part of it. So earlier the penalty was non-compliance of section 143.12 whatever 143, you read that. So 1 lakh to 25 lakhs was the penalty earlier. Now this has been brought down to 5 lakhs. Listed companies, see, the beauty here is that earlier it was if you don't comply with section 143, auditors were subjected to a penalty of 1 lakh to 25 lakhs. Now they have bifurcated into listed companies and non-listed companies. So listed companies, it is 5 lakhs, and companies which are not listed will be 1 lakh. So from 25 lakhs maximum, it has been brought down to 5 lakhs listed, 1 lakh other companies not listed. So then this we will come to it later. Yeah, companies to have board of directors. This is under section 149. This you have to read with, I have already told you in the beginning, this you have to read with section 149 and 140. 149 you have to read with section 197. This is basically in the context of, as I was telling you, remuneration of independent directors and non-executive directors. So the schedule 5, applicability of schedule 5 and payment of remuneration to non-executive directors and independent directors is also permitted when there is inadequacy of profits or losses. Apply the percentages that are given in the schedule 5 and then you can pay them. This is the amendment here. The number of directorships, section 1, the 160 for disclosure intention of the director. I think small time. Let me see. See, disclosure of interest by director. As we are aware, every director will have to disclose interest. How does he disclose interest? He has to disclose at the first meeting, the moment he is appointed, at the first meeting of the board meeting, at the first meeting of the board after his appointment, where he participates as a director, and at the first board meeting in every financial year, and where there is any change. So the point is that every director will have to give, you have to disclose his interest in the other companies, in the other firms, bodies, corporate, all kinds of these these organizations, what kind of interest he has got as a director, as a partner, as a member, private limited company member, and all this information you have to give it to the company immediately after you appointed in that company, and definitely by that day, by the board meeting, in the first board meeting itself, at least you have to disclose. So immediately you disclose, otherwise disclose at the first board meeting. And after that, every year, for every financial year, you have to disclose in the first board meeting. So financial year starts from 1st April. So whenever the first board meeting takes place, you give the interest of the entire list. From that day, new list you have to give. And in between also, if there is any changes, you need to intimate to the company what are all the changes, the disclosures that you have already given. Every director of a company who is in any way directly or indirectly concerned or interested in a contract or arrangement. This is the second subsection. What it says is, when any discussion is going on in the company, we have to disclose that these are all the agenda items where I am interested, and you should not participate. You should abstain from attending the board meeting where that item is discussed. Then it's okay, we will go to that. And if any other rule, okay, rules also is okay. Interested, see, if you have interest in other company means 2% or more than 2%. See, if it is 2% or less than 2%, it's okay, or not treated as interested, but you will be treated as interested director if you hold more than 2% of the shareholding. Then what are the penalties? Earlier penalty was such director who is supposed to disclose and has not disclosed or has not complied with these provisions, such director will be responsible. Is a very important provision. That director would be responsible as per the old provision, imprisonment of 1 year and fine of maximum 1 lakh or both. Imprisonment 1 lakh up to or both. Earlier provision. The new provision is, in case you violate with the section 165. No, not this. This is not that. I'm sorry. This I am talking to you about section 184. This is 184 I am talking. So this is a old provision. If you don't disclose properly, or you have defaulted in giving the disclosures, old provision is 1 year imprisonment for every such kind of a thing for a director, and fine up to 1 lakh rupees or both. Now the new provision says that such director shall be liable to a penalty of rupees 1 lakh, only 1 lakh, and then imprisonment is done away with. There is no imprisonment now. Then we have related party transactions. This is a very, very important thing. Only this subject you can discuss more than 3 hours or 6 hours even. Even 6 hours are not sufficient. But anyway, even 1 week will be probably sufficient. Every day 2-3 hours, 1 week will be sufficient. Maybe related party transactions. This is in section 188. No company shall enter any contract or arrangement with a related party except with the consent of the board of directors. So board of directors will have to give the consent to enter into an agreement with the related party. And then rule 15 of the company's meetings of board and its powers, rules 2014, we have to refer to also. Then what are the issues? Sale, purchase or supply of goods or material, selling or otherwise disposing of or buying the property, leasing of the property, availing the services, appointment of any agent, underwriting, so on and so forth. No contract shall be done with. I am not giving you in detail, but you see, even if a person is being appointed, you see, one person is being appointed, he is relative of an existing director, he is an interested party, then the limit prescribed is 2.5 lakhs. If you are appointing somebody who is related to the director, since he is a related party, if the salary being paid is 2.5 lakhs or more, then naturally up to 2.5 lakhs permitted. So beyond that 2.5 lakhs, you have to follow these provisions. There are certain more things, that it is board of directors permission at one point, and board of the directors concerned or interested should not participate. Give the proper, that intimation of the disclosure. And again, for these sale, purchase, and underwriting services, they are provided certain limits like 10%, and then 100 crores. Details I'm not going. You can read that. So these things are to be complied with. And services, explanatory statement 101. Okay, that these are all the details which I am not going in. But if we have not complied, there is a default. If there is a default in any of the, I am just seeing the time. If there is any default in any of these provisions, any director or any other employee of a company who had entered into or authorized the contract or arrangement in violation of provisions of this section, old provision is imprisonment of 1 year and fine of 25,000 to 5 lakhs, or with both, for any director or any person who has been behind the entering of this related party transaction. And Now that new provision is there is a change. See, in the earlier one, if you have not complied with the related party transaction provisions under section 188, old provision was in case of a director or any officer who has actually behind the entering of related party transaction, imprisonment of 1 year and fine 25,000 to 5 lakhs when that company is a listed company. The companies which are not listed companies, in the old provision, 25,000 rupees to 5 lakhs, unlisted companies. So what is the new default provisions? Penalty for the default: listed company fine only up to 25 lakhs, and other than listed companies 5 lakhs. So you will observe one important thing here: the company fine has become 25,000 to 5 lakhs to it has gone to 25 lakhs. And unlisted companies fine is 5 lakhs. But the thing is that imprisonment has been completely removed. Overall maximum remuneration, okay, we have touched upon that. Secretarial audit, it may not be very relevant to you, but still, it is relevant to you also in any case. If you are not complied with that, if any that company has not provided with the any officer in the company or the company's written practice, the old provision for default is 1 lakh to 5 lakhs. Now it has come down to 2 lakhs. Merger and amalgamation. I will take you only 2 provisions which are very important, and then we can close this. Okay, so now see this is that whenever you think in terms of, as I was mentioning you, the Madras Bar Association versus Union of India and the Supreme Court, and also I mentioned Swiss Ribbons case versus Union of India and the Learned Council. There in that that in the case of those arguments in the Supreme Court, he was mentioning that the government of India has not complied with even the appointment of members of NCLT and the NCLAT have not been done according to the verdict of the Supreme Court in the Madras Bar Association versus Union of India case. And then it was also a point in that Swiss Ribbons case that the chairman and the members of the appellate tribunal, also NCLAT, and also there was another important provision that, as you are aware, some of you or all of you might have read the Madras Bar Association case. If you have not read, you should read that. At least Swiss Ribbons case you must read. The name is Swiss Ribbons case, Swiss Ribbon Limited versus Union of India. Swiss Ribbon versus Union of India. If you read that case, you will get all what I am telling, which has led to this amendment. So now what they have amended, they have increased the number of members of the NCLAT and NCLAT, NCLT. So there was the maximum number prescribed earlier as 11 number, that has been removed, and then Government of India, in consultation with the chairman of NCLAT, they can increase and go beyond 11 number of members. Then another important thing is in that again Swiss Ribbons case, the Learned Council, he was mentioning in the Supreme Court that the Government of India has not complied with having the benches of the NCLAT. See, NCLT you have in Cochin also, but NCLAT is there in Bangalore, Hyderabad, Chennai, all these places. But NCLAT is not there. NCLAT is there only in Delhi. So all people for appeal, appellate authority is adjudicating authority, NCLAT is there, all these places, at several places. But NCLAT is not there. Then all these people after NCLT, if there is any appeal, they have to all the way travel to the Delhi. Otherwise, it was earlier, all these cases were handled by the High Court, and High Courts are there in every state. So every state used to address every state's High Court used to have this jurisdiction and do that. Now today, High Courts do not have any jurisdiction, and from NCLT you have to go to the NCLAT, that you have to go to the Delhi. This was one observation made. But that now what they have done in the Amendment Act, they have made a provision, they have amended. And then they said that now in the Government of India will be empowered. Now the Amendment Act has given power to the Ministry of Corporate Affairs, that is central government, to have more benches of NCLAT in consultation with the chairman and then all these people. So this is regarding the constitution of appellate tribunal. This comes under section 410. Then 418A also, new section incorporated 418A, that also I have told you. Then I told you one more thing is that compoundable of certain offences. See, offences are, what are the offences? That you default and then offences, the penalty will be monetary penalty and then monetary and then imprisonment, or with both. So these things have been decriminalized, and then some of the things have been brought down to regional director. Okay, regional director, and then it will come to the administration instead of the NCLT and NCLAT, like that. Then this is the last provision more or less. So before that, I will take you to one. This is I will take another 3-4 minutes, Varghese sir. So this foreign companies, 393A, which I told you, companies incorporate outside India. Chapter 22 of the Companies Act 2013. This is 393A is a new section that has been added now. So these foreign companies, they are dealt with between 379 and 393 under chapter 22. So that few issues of this new company, the foreign companies, is they have to intimate about their place of office in India, and then who are the directors, so on and so forth, whatever the information is given. And then the punishment, punishment, and then these things have been provided there, and then that is not much here. So the government of India is now empowered to make rules, and then now section 393A, that has been included. The central government may by notification. So 393A, which I told you, in the 393A, in case of foreign companies, that is companies incorporated outside India, the central government may by notification. The central government may by notification exempt any class of foreign companies incorporated or to be incorporated outside India, whether the company has or has not established so far the business as may be specified by the notification from any of the provisions of this chapter. So 20, as I told you, this chapter 22 is related to the companies incorporated in foreign jurisdictions. So these companies will be, the central government is empowered to exempt certain kind of a thing. And last thing is that, lesser penalties, the penalties have been reduced. This is 446B. New section has been incorporated. As per this section, the compliances and the penalties, and these companies will be having lesser penalties. What are these companies? New section 446B empowers that these companies will be subject to lesser kind of penalties, maybe 50% of the penalty that other companies will have to pay. So that is, what are these companies? OPC, one-person company, small companies, and then startup companies. Startup companies are defined. A startup company is a company, startup company is a private limited company, as notified by the central government in the Department of Promotion of Industry and Internal Trade. So these kinds of things are provided. So relaxation has been provided as per 446B in the case of these set of companies, OPC, small company, startup company, and the producer company included. So now these are the things, by and large we have covered everything. I will just show you exemptions under, okay. I have told you, these NCLT, all these provisions I have already told you. Okay. Lesser penalties, this just now I told you 446B. this is another thing, punishment for wrongful withholding of property, that you can read it later. Adjudicating of penalties, I told you. Repeal of certain act means section 454. See that when the producer company provisions have been brought to Companies Amendment Act 2020, and they are now included in the Companies Act 2013. So this chapter 21A is included to the section 21 in the Companies Act 2013, that is under the head producer companies. So whatever the provisions we had in the Companies Act 1956, till now we had provisions for the producer companies in the Companies Act 1956. They are now being repealed. So the old 1956 Act producer companies provisions removed, and then now we have new provisions, new set of provisions in the Companies Act 2013 through the Companies Amendment Act 2020. So these are all the basic things that are there in the that producer company, that sections I told you, 378A to 378A, A, B, A, C, A, D, like that, 378 A, U. Up to that we have definitions, objects of producer company, like whatever we have our normal companies, private limited or public limited. What are the things that we have? We have membership, we have formation, we have objects, we have memorandum, we have benefits to members, we have articles of association, we have amendment of memorandum and articles, and then effect of incorporation, vesting of undertaking, and then number of directors, appointment of directors, vacation of office by directors, and including liabilities of directors, committee of directors, voting rights, CEO, quorum. All these things are detailed discussed in each section in the Companies Amendment Act 2020 as to the producer companies under section 378 in chapter 2022, which I told you. Okay, this is all what 21A. This is all what we have in the producer company, but I am not going deep into the thing. But in any case, we don't have time. I think I am done with Mr. Varghese.
Sir, I think any questions? I think.
Yeah.
Yes, sir. There are few questions from members, whether it is notified or not, whether it is applying to private companies. That is the first question, sir.
No, that way, as far as that is concerned, not yet notified. So the companies which have been dematted for the purpose of members register, and that it will be the NSDL, CDSL, those kinds of things are accepted. Notification has yet to come. Next.
Now, once it will be notified, will it be applicable to private companies?
See, actually, let us see we have to see the notification.
Okay.
Because you see, actually, the listing exemptions which they are removing from the section 252, some of these companies, debenture companies, are also were asked to that have that debentures listed. So let us wait and see how it will.
Okay.
But securities will be most probably exempted. Okay, next.
Next question: whether section 135(5) is notified related to CSR payment to separate bank account, if not spent fully. Whether
Yes, sir, that is there.
Pardon?
Yes, sir. That is there now already. Separate account, we have to do that.
Yes, and deposit within 6 months from the end of the financial year. Okay, sir.
Yes, sir. Yes. Those things have not been any change. Only 2 changes in section 135. Subsection 5, there is not much change actually. So the 2 changes are, if you have the total amount not more than 50 lakhs, then you don't need to have CSR committee. Then if you have spent any money in excess of 2%, you can utilize in the future years.
Okay, sir. The next question: is there any restriction under FEMA in obtaining unsecured loan from NRI directors by a company other than from their NRO accounts?
I don't think that I think no that needs to be referred. I'm not prepared on that.
Okay. That is the end of the question, sir.
Yes, sir.
Over
Yes,
to
thank you.
you
Chairman.
almost covered all the very important provisions or sections where amendments have been done, and highlighted those sections to the members. It was a very lucid presentation, very informative. As you mentioned, if you need to go through all the 61 amended sections, it will take minimum minimum 1 day. I think you should spare it for a very detailed discussion of all. And in certain sections, I think you asked 188 and all, you are telling that you can go on talking, and even 6 to 7 hours or 8 hours, I